panel of the day on the Constitution Restoration Act and judicial independence. Professor Tushnet's paper on providing some observations on a piece of legislation proposed to limit the ability of the Supreme Court to consider or to rely upon foreign law. I think this is a particularly timely topic, not just the specific legislation that Professor Tushnet is considering, but more broadly the question of congressional efforts to limit, constrain, or otherwise control the jurisdiction of federal courts or the way in which they reach their decisions. As I think most of the students in this room know, having been taught constitutional law from Professor Tushnet's casebook, this isn't the first legislation of this type that's been proposed. There have been legislative proposals to, for example, limit the ability of courts to hear certain types of church-state cases or establishment clause cases, clearly motivated by concerns about how federal courts might resolve such cases. We have seen more recently legislation that in certain ways limits the ability of federal courts to hear certain sorts of claims related to the detention of enemy combatants and the war on terror. So there are certainly many broader issues at stake here that make this an important issue. Professor Tushnet, who's presenting the paper, is, I think, known to all of us here. He's he's the Carmack Waterhouse Professor of Constitutional Law at Georgetown University Law Center. He's a former president of the AALS, a former clerk to Justice Thurgood Marshall, and as I mentioned, co-author of a constitutional law casebook, I believe the leading constitutional law casebook these days. And among other things, most relevant to our discussion today, one of his many books is Taking the Constitution Away from the Courts. Commenting on his paper are Professor Marci Hamilton, who is Paul Verkuhl Chair in Public Law at the Benjamin Cardozo School of Law, Yeshiva University. She clerked for Justice O'Connor, and among her many writings is the recent book published by Cambridge University Press, God versus the Gavel, Religion and the Rule of Law. She's also a columnist at finelaw.com. And then Professor Ronald Kahn, James Monroe Professor of Law and Politics and Director of the Law and Society Program at Oberlin College. Like all of our panelists, author of many books on constitutional law and the Supreme Court, including the Supreme Court and Constitutional Theory, 1953 to 1993, and the Supreme Court in American Political Development. You've all come to hear their thoughts on this subject, not mine, so without any further ado, I will turn it over to Professor Tushnet.
Thank you. I too want to thank the organizers of the panel, and it turns out that you probably want to thank the organizers of the symposium as well, because they've managed to structure this, I think, entirely unintentionally, so that the last speaker is going to provide a certain amount of, I hope, comic relief. The reason is that I am going to be talking about a statutory proposal that hasn't been adopted, and you probably haven't heard of it, and it probably has no chance of being adopted, and I'm going to take it seriously. Now, okay, so, but I think the statute, the proposal does provide an opportunity to explore some aspects of concerns about judicial independence and mechanisms of control that might have some broader implications. This proposed Constitutional Restoration Act is introduced in the House and in the Senate and has a non-trivial number of sponsors, but clearly is not a high legislative priority of anyone. It has several provisions. One is a jurisdiction stripping provision. I'm not going to talk about that. I'm going to talk about the other set of provisions, and I just want to read the two relevant ones that I'm going to talk about. The first, it says, in interpreting and applying the Constitution of the United States, a court of the United States may not rely upon any constitutional law, administrative rule, executive order, directive, policy, judicial decision, or any other action of any foreign state or international organization or agency other than English constitutional and common law up to the time of the adoption of the Constitution of the United States. This is a reaction to what I'll describe in a moment as references to non-U.S. law in some recent Supreme Court decisions. And then second, it backs this prohibition up with a provision asserting that if you, relying on non-U.S. law this way, and I'll quote, shall be deemed to constitute the commission of, one, an offense for which the judge may be removed upon impeachment and conviction, and two, a breach of the standard of good behavior required by Article 3, Section 1 of the Constitution. Incidentally, if anybody can help me on figuring out why you need both of those provisions, that would be, it would be actually interesting. That is, they seem to think that there's some distinction between grounds for removal and breach of good behavior. But in any event. Now, I don't think that the statute has a decent chance, serious chance of enactment, and I'll talk about why it might have been introduced in a moment. I'm going to start by treating it as a real statute. That is, if you were a legislator, what might you be, and this were enacted, what would it do? The major question is what constitutes reliance upon non-U.S. law and constitutional adjudication. There are some minor puzzles associated with it. My favorite one is the exception for pre-adoption common law. The reason for that is this problem has actually arisen. If the statute were adopted, we have an example. There's a decision, an opinion by Justice Stevens in a case in which the court denied cert, and Justice Stevens wrote a separate opinion concerning the denial of cert. He didn't dissent from the denial of cert. It was one of these recurrent claims about prolonged detention on death row being cruel and unusual punishment. In the course of that opinion, Justice Stevens refers to a 1983 opinion, 1983, written by two judges in the British House of Lords. And in their opinion, they said such detention would have infringed the prohibition against cruel and unusual punishments to be found in Section 10 of the Bill of Rights, 1689. Okay? So now, the British decision was rendered after 1789 or 1791, but it purported to interpret a pre-adoption statute. Has Justice Stevens relied upon pre-adoption or post-adoption English constitutional or common law? Or another example, what people have called aversive constitutionalism. A court refers to constitutional decisions elsewhere as a reason for rejecting a proposed interpretation of the U.S. Constitution. So in Canada, there's a decision called Keegstra, which upholds hate speech regulation. Suppose a U.S. judge mentioned that decision to show that enforcement of anti-hate speech regulations threatens a slide down a slippery slope, and that the First Amendment should therefore be interpreted to impose substantial restrictions on the adoption of hate speech regulation in the U.S. Has the judge relied upon Canadian law in interpreting the U.S. Constitution? Well, yeah, sure. It's a reason, if they do it there, bad things happen. That's why we shouldn't do it here. Looks like reliance to me. Third, there's a problem of unexpressed reliance. A judge consults a wide range of materials, including non-U.S. materials, in the quiet of his or her chambers, and then writes an opinion relying on the non-U.S. materials, but not mentioning them. The opinion might use the concepts the judge became familiar with in doing the research, or might interpret domestic doctrinal terms informed by the interpretation of parallel terms in non-U.S. law. Has the judge relied on non-U.S. law within the statute's meaning here? And if so, how would you ever know? Now, these are small puzzles. The more important is the behavior that appears to have motivated members of Congress to introduce the proposal. The behavior, as I've said, is the reference in recent Supreme Court constitutional decisions to non-U.S. law. I use the term reference deliberately here to point out that In most contexts, we distinguish between references to non-U.S. law and reliance upon it. And what I want to do is read one of these references in some detail in its entire context. Comes from a footnote in Atkins versus Virginia, which held it unconstitutional to subject criminals who had mental retardation to the death penalty. And this is the footnote. Additional evidence makes it clear that this legislative judgment, that is a judgment that the court finds has been made by U.S. state legislators. Additional evidence makes it clear that this legislative judgment reflects a much broader social and professional consensus. For example, several organizations with germane expertise have adopted official positions opposing the imposition of the death penalty upon a mentally retarded offender. See Brief for American Psychological Association et al. As Amici Curiae. In addition, representatives of widely diverse religious communities in the United States, reflecting Christian, Jewish, Muslim, and Buddhist traditions, have filed an amicus brief explaining that even though their views about the death penalty differ, they all share a conviction that the execution of persons with mental retardation cannot be morally justified, citing another amicus brief. Moreover, within the world community, the imposition of the death penalty for crimes committed by mentally retarded offenders is overwhelmingly disapproved. Brief for the European Union as amicus curiae in a related case. Okay, that's the reference. That's the whole reference. Justice Scalia derided that reference in that final sentence by awarding it a share of the prize for the court's most feeble effort to fabricate national consensus. Now, I think that at least in ordinary terms, there's a general question about whether that reference constitutes, counts as reliance upon non-U.S. law in any ordinary sense. It occurred to me as I was going over these remarks that maybe they're not relying on the substance of the foreign law, but they are relying on the brief of the European Union, and the filing of the brief of the European is an action of an international organization within the meaning of the statute. You could do that if you really wanted to, but it's not the natural reading of the statute. In the paper, I also talk about Roper and Simmons, and a more recent case. I'll just describe in briefly the structure of the Roper opinion. It has two or three operative sections. Section 1, the court says, the majority says, there's a trend against the imposition of the death penalty on offenders who committed their crimes when they were under 18 years of age. Trend in U.S. statutory law. That's Section 1. Section 2 says, when we look at our precedents, they tell us that we, the Justices of the Supreme Court, are entitled to, indeed must, exercise what the opinion calls our independent judgment on the value of various sorts of value of imposing the death penalty. And as we exercise our independent judgment, as our precedents say we should, we conclude that the death penalty under these circumstances is unconstitutional. And then there's the third section. The third section says, when we look that these prior conclusions, that is, these two other parts, the trend in domestic law and what an independent judgment reveals, these two conclusions find confirmation in practices elsewhere in the world. Now, does confirming a judgment already reached, which is what the structure of the opinion says it's doing, by checking it against judgments made elsewhere, constitute reliance upon non-U.S. law? Now, my personal view is that our ordinary language usages would lead us to conclude that neither Atkins nor Roper, nor I believe any of the other recent cases in which the Supreme Court or individual justices have referred to non-U.S. law, involve reliance. They involve references. Perhaps we should take the term rely upon to be a term of art, a phrase that uses words familiar in ordinary language but gives a specialized meaning in this context. The question would then be, where do you get the source? What are the sources from which we can discern the meaning of the term of art? Ordinarily, you'd say terms of art get embedded in the law gradually. They start out having close to their ordinary meaning in cases or statutes, but as time passes, they take on a specialized meaning. I don't know of any other statutes in which the term rely upon has a relevant specialized meaning. The remaining possibility is that that term would be given meaning in practice, that is, in the impeachment proceedings that are contemplated in the enforcement provision. And I'll talk about the impeachment provisions in just a couple of minutes. If we can't treat rely upon as a term of art, we'd have to face interesting questions about statutory interpretations. I have no doubt that the sponsors of the proposal believe that they're addressing a class of decisions that includes Roper and probably Atkins. The natural reading of their statute leads to the conclusion they've missed their mark. In such circumstances, should we interpret the statute to do what the sponsors intended or what they said? Now, in the former case, the term rely upon means what the proposed statute sponsors subjectively intended it to mean. And I just note the irony of taking this course in a context where Justice Scalia, probably the most prominent critic of references to sponsors' subjective intent in statutory interpretation, has been one of the moving forces in bringing critical public attention to the issue of references to non-U.S. law in Supreme Court cases. Okay. Now, assume that the statute applies to Roper in similar cases. Is it constitutional? Can Congress prescribe the interpretive methodology that the federal courts must use? Or more precisely, can it proscribe a particular interpretive method? I begin with one strong intuition and one precedent. The intuition is that constitutional interpretation and the choice of methods of constitutional interpretation is at the heart of the judicial enterprise, and so there's a question about attempting to constrain a constitutional interpretation by the judges. Now, I should note there's a contemporary controversy not yet authoritatively resolved that indicates that the problem of legislative constraints on constitutional interpretation are not entirely new. The Anti-Terrorism and Effective Death Penalty Act states that federal judges can issue habeas corpus relief only if they find that the petitioner's rights were violated when measured against clearly established federal law as determined by the Supreme Court of the United States. The statute appears to preclude a federal judge from issuing relief based on, for example, circuit precedent. In an early case interpreting the statute, Judge Kenneth Ripple of the Seventh Circuit argued in dissent that this restriction interfered with the court's ability to exercise the judicial function. Congress, he wrote, has no power to dictate how the content of the governing law will be determined within the judicial department. The majority dealt with that objection by saying, well, we don't know about substantive constitutional interpretation, but habeas is a remedial scheme, and Congress does have the power to structure remedial schemes. The Constitution Restoration Act is about the substance of the Constitution. Okay, so there's this question about congressional power. I said there was a precedent and that also was applicable here. The precedent is United States in Klein, which holds that Congress can't dictate a rule of decision about a constitutional provision's meaning. But prescribing a rule of decision is simply an extremely severe constraint upon the interpretive methods judges use. So Klein indicates that severe limitations on methods are unconstitutional. It's at the end of a continuum. The intuition that the choice of interpretive methods is at the core of the judicial function suggests that Congress lacks power, even when we move away from Klein's extreme. And yet I doubt that Congress lacks all power to prescribe interpretive methods. My example is a statute that bans federal courts from using Latin phrases other than those commonly found in legal dictionaries, adopted to ensure that federal court decisions would be accessible to ordinarily literate Americans. And I have a quotation from Swift and Tyson that goes into, and it's got an extensive Latin sentence, the meaning of which I can sort of figure out, but okay. So the constitutional standard would be one of degree. Congress has some power to prescribe interpretive methods, but can't exercise that power to a degree that would substantially impair the court's ability to perform the job of constitutional interpretation. People differ about whether the Constitutional Restoration Act violates that standard. For what it's worth, my tentative judgment is that it doesn't. The practice at which it appears to be directed has played a rather small role in recent constitutional interpretation, and depriving the courts of the method wouldn't, I think, substantially limit their ability to do the job the Constitution gives them. I have less than a minute left. I just want to say a few things about the impeachment dimension of this. Why might such a statute be thought necessary? Assume a majority of representatives believes that a judge who relies on non-U.S. law should be removed from office. Does the act strengthen their position? Well, in some sense, I think it may. We know that we heard this morning from the failed impeachment of Samuel Chase that the law of impeachment is that you can't remove a federal judge from office merely on the basis of disagreement with the judge's rulings. You've got to have something more. I think the something more might well be a statute like or disregard of a statute like the Constitutional Restoration Act. After the adoption of the act, a member of Congress can say of a judge, I'm not simply disagreeing with a reliance on non-U.S. law, which is bad enough. This judge defied the law, which certainly ought to be ground for removal. Okay, so I guess the last thing I want to say is, so I actually think the act might do something in the impeachment context. The other thing I want to say is, why is this statute being adopted? Well, or proposed. Partly it's just grandstanding. Partly it's position taking, and as we've heard in the last panel, signaling to the courts. Although I have to say, signaling by means of legislative proposal that isn't adopted doesn't strike me as a terribly effective mechanism. That is, if I were a federal judge and saw this, I'd say, oh, there are these crazy people, not a majority of the House or Senate, who don't like what I'm doing, but a majority doesn't seem to be bothered enough to go after me. And finally, it also occurred to me that there is an interesting strategy available to the people who like the references to non-U.S. law. And that is for, let's say, Justice Kennedy to get the assignment of an opinion in a case in which the court is unanimous in upholding a statute against constitutional challenge, and then put in all these references to non-U.S. law to explain why this statute is perfectly constitutional. That's not how the sponsors of this resolution think that the court is using non-U.S. law. He might get some advantage out of doing so. Thank you.
Let me thank Sarah Bush and the Law Review for inviting me today. This has been a very interesting gathering, and I just want to give Sarah Bush her props because she emailed me originally during a month when I was solemnly determined that I would not accept any more invitations for a year. And then she emailed me the next month, and here I am. So anyway, I want to thank Mark Tushnet, too, for bringing the CRA to my attention. What a fun thing for Congress to be considering. And essentially what I'd like to do is to talk about congressional responses to the court in recent years, and I don't think there's any accident that the two acts that I'm going to talk about have similar words, the Constitutional Restoration Act and the Religious Freedom Restoration Act. Congress is really into restoration right now. So let me talk, I want to start with bedrock principles that the framers, we can all agree that the framers would agree on. They're so basic. One, there was just a pervasive belief that anybody who held power is likely to abuse it. That was just pervasive at the convention. It was the apex of Calvinist Presbyterian thinking. It's the only time, actually, in American history that Presbyterians can take some blame or credit. And also that the legislature is the most dangerous branch. And so if you look at Federalist number 51, you see that quite blatantly, but of course you can't trust the Federalist Papers because they're propaganda. So then if you look at the notes of the debates of the convention, you'll see it's also true. They thought that the legislatures were cabals and vortices of corruption, one of my favorite phrases. So the question is, if you have a voracious power for a desire for power coupled to the most dangerous branch, you would expect some expansion of power, some kind of alteration in the universe that Congress thinks that it governs. And guess what? Congress has been very adroit at drawing to itself power that maybe was not thought at the founding to be belonging to it. There was a time when Alexander Hamilton was heard to say that it was inconceivable that Congress would take over the laws that the states were going to retain because they just weren't of interest to Congress. And we reached 1995, and it turns out there's no arena that Congress does not feel perfectly competent to regulate, and it's been reinforced in that all through the 20th century because the court has not told it that it doesn't have plenary power at any point. So we get to 1995 when the so-called federalism revolution, but I would call tiny adjustment, starts. And the question before the Congress at that point is, up till 1995, they don't even ask if they have the power to enact a law. So they enact, 1993, they enact the Religious Freedom Restoration Act, which is a law that's going to impose strict scrutiny on every single law in the entire country. And the basis for their power is analyzed in a one-page letter from a law professor. They're just not concerned that there's any particular limit on their power. Then we get the new Constitutional Restoration Act proposal. Well, we've moved from the question of are there any limits on the arenas within which Congress can enter to the question, can it take over the functions of the other branches? Because this is a proposal that does not talk about outcome or policy. They didn't sit around and well, they haven't done anything yet, but they won't, let me tell you. They will not sit around and talk about, the reason we're doing this is because we think this will get us more clean water, or this is a really great way to protect children. Really what they're interested in doing is micromanaging the way in which the court operates through its thought processes, not just through the money that the court receives, as we heard from the last panel, but just the way the court is thinking about issues. So this is a further step in the willing expansion of power that Congress has been willing to take. But in my view, the Religious Freedom Restoration Act is even broader because the Religious Freedom Restoration Act is the quintessential example of tit for tat between the branches. So the Supreme Court decides Employment Division versus Smith, says neutral, generally applicable laws receive low-level scrutiny, and 3 years later, Congress responds and says, oh yeah, guess what? You apply strict scrutiny. They don't say, you know what, I think there's some religious liberty problems in the country. We're going to make it easier for people to get to avoid autopsies if they don't believe in autopsies in certain circumstances, or we're going to make it easier for faith healers to be able to avoid criminal prosecution. They pass a law that says to the court, here, this is your standard. You created this standard. Now you apply the standard that we choose. It's a radically different approach to congressional lawmaking than we'd seen up to that point. And so the two Restoration Acts are not substantive in the sense that they are policy making, but rather they are determined to micromanage the internal dynamics of how the court reaches decisions. That is a much larger grab for power than the preceding 70 years. And I think it's interesting that the CRA comes into being after the court has actually tamed down its federalism cases a bit. I mean, there was this original hue and cry that it was going to be the end of the universe, that the court would say any of Congress's enactments were unconstitutional. Now the court has actually, there's no debate on the court anymore. It's just part of the analysis. There is a federalism doctrine. But when the federalism doctrine is applied Sometimes, in fact, many times, the court upholds the statute. So Tennessee v. Lane holds up Title II of the ADA, right? And we get Raich, the medical marijuana case, upholding the Controlled Substances Act in conflict with state law. So essentially what you have is the Congress expanding to fill the space that it thinks it can fill. And the both CRA and RFRA are examples of the continuing focus of the Congress not on policy, not on creating substantive law, but on altering the way in which the judiciary operates. Now, the RFRA, of course, was held unconstitutional in Bernie in 1997 as applied to the states. I think it was also held unconstitutional as applied to the federal government, but Congress, as soon as Bernie came down, amended RFRA to say we will now apply it to federal law, as though the decision had said nothing that would be relevant to federal law. So, I mean, why read the decision when you could be right? So the Congress continues to believe that it can not only be in control of every arena in the country, but it can also be in control of the way in which decisions are made. And so RFRA is held unconstitutional in 1997. In 2000, Clinton signs into law the Religious Land Use and Institutionalized Persons Act, which is our LUPA. Right? Now, our LUPA combines both of these trends. It's really the CRA and RFRA in one pocket. Because what it is land use. It is the federal government micromanaging land use, which you would think is local. Land is hard to move, and I mean, if there's anything that's inherently local, it's got to be land. I am going to stand by that. So it combines going to an arena that the Congress knows absolutely nothing about. The notion that Congress could have debated whether or not setbacks for churches should be 20 feet or 200 feet, they couldn't have done it. They're incompetent. They know nothing about land use law, but they're more than willing to take over any arena that's available, plus they're more than willing to assign the court the level of scrutiny it will apply in whatever arena it points the court toward. So our LUPA says the courts will now apply strict scrutiny whenever a land use law burdens a religious entity. Now, that's a third actual iteration of the expansion of their power, because the Federalists assumed that with the enumeration of powers in Article 1, that you would never have to have a Bill of Rights because there was no power over religion in Article 1. So when the idea was, we better get a Bill of Rights from the Anti-Federalists, the response was, well, that'd be crazy. You don't need that. There's no power over religion. Well, our LUPA combines it all, right? Power over what's inherently local, the ability to tell the court what standard to use, right? I mean, this is megalomania, right? Now, the question is what do you do about it? Because I think in the end, the trend is not good for the courts. The courts are being displaced not just with respect to the fact that the Congress has now expanded its universe so broadly it has enough power to stop the court in many circumstances, but the Congress is now thinking in terms of how to micromanage from the inside. So I think it's extraordinarily important that we must find a meaningful way to keep judges independent, because it looks to me like that is an increasingly difficult task. Now, so I think that the CRA is troubling. The very fact it was introduced is troubling because it gives you a mindset about the power that Congress conceives that it holds. So in the end, the question, though, is what is independence? That is the hard definitional task for the day. And what I heard early this morning was that positive law is the limitation on the judiciary. And so if the judiciary does not abide by positive law, then it has not, in fact, done what it ought to have done. That seems somewhat troubling to me, because what that means is that law created by the legislature turns the courts into automatons, right? The old model, or the traditional model, or the virtuous model of the courts is that they are the body capable of mercy and justice, right? They're the ones who can moderate some of the harsh impacts of the way in which the law impacts any one particular individual. And the two examples we had this morning are perfect, right? The one example of the judge just does not want to impose the 25% in the credit card case. And then the federal guidelines, right? They just can't bring themselves to put someone in jail for 50 years for whatever infractions in front of them. And those are cases where the judges are being driven by a concept of mercy and justice, which is mediating the law. So if positive law is in fact a complete block to the exercise of judicial judgment, then judges have been reduced to automatons being told what to do in each individual case. If not, if in fact positive law is not enough, that the judiciary holds something that the other branches don't, and that's the ability to decide cases on a case-by-case basis, which of course is required by the Constitution and the case and controversy requirement. But if that's in fact what independence means, and I actually think that is close, getting closer to what independence must mean, then the CRA is extremely troubling, and the only way for the judiciary to be safe is for there to be mechanisms to protect the judiciary from these increasing power grabs. So let me just leave you with my recommendation. I do not think we should have the Constitutional Restoration Act. I'm sure you know that by now. But I would like to propose a different CRA, the Congressional Restoration Act. And what it would be is it would be animated by Alexander Hamilton's belief that Congress would never even want any of the state's powers, because who would want to do divorce law? And I think that we should reimpose that viewpoint on the Congress, and if they stray beyond it, too bad. Thanks a lot.
I'm the anchor man on the anchor panel on the anchor day of the week. But hey, I want to thank Sarah and the Case Western Law School for inviting for this very, very stimulating conference. When I was asked to do this paper by Mark Tushnet, I was doubly delighted, having read Mark's superb works over the years. You know, now I have a chance to make a sense of the theory of his theory of the political constitution. You know, look at it, you know, as a real issue in terms of the Constitution Restoration Act. For questions of judicial independence, like, you know, theory and practice. Oh, it's great. So I'll speak about independence, but I'll more talk about theory. Over the decades, Mark is one of the few, but growing, luckily, constitutional scholars that take serious the work of political scientists. So again, the two coming together, I think both fields are better off for it. So I got Mark's paper, and oh my, the paper is 12 pages, right? Right? Aha, my lefty Straussian instincts have come alive. I will read it like I'm reading the Torah, right? Because, I mean, in every word. So this is what I did. I took the paper and I said, okay, what does this mean? And when you read the paper and you read it carefully, you find, and you read it in the light of his books of the new constitutional order and taking the Constitution away and other things he's written on constitutional as political law, you start getting a sense of what he's saying. And what he's saying, I was a bit shocked. He says, no big deal, right? Every time you look in the thing, it's no big deal, right? This is not, you know, and I'll talk about the no big deal. No big deal because the vagueness of the terms makes it unclear in terms of the reference to as he spoke, in terms of relying on versus having no big deal. Okay. If you look at in terms of the constitutionality, well, everything's a matter of degree, right? In degree, no big deal. You know, courts will interpret and politics will do their things. What about congressional aggrandizement? No big deal. All right. You know, and he goes through a very, very assiduous thing about why it's no big deal. Impeachment, no big deal. Why is it no big deal? Well, because people can use the law and say it's the law, but they're just going to use the law politically. I'll talk about this in a minute. So I said, why no issues of independence of courts? Why is it no big deal? To understand this, you have to get into Marx's concept of the legal and the political. And to do this, you have to work outside the paper, right? And I'm saying, look, a Leo nomination, abortion rights are on the line, conservatives taking over Congress, and Marx is saying, no big deal. All right. Now, so I'm saying, why no big deal? And I think that is a big deal. And I tried to answer this question, I'm answering this question, why no big deal? What you find is that the concept of the legal, when he talks about legal within the political system, the legal is, they used a legal argument. It's a policy argument. In other words, they talked about the law. It's a policy argument. Therefore, it's legal because they didn't just talk about preferences in terms of, you like butter, I like peanut butter and stuff like this. So it's that's the legal. And I said, wait a minute, that's the legal? Okay, there's politics and legal in Congress and what politics does. Then when you get into the question of the courts, he always says, we as constitutional scholars know what courts do. We know what courts do. They do law. It's interpretive. Then you look in the paper further and you say, well, what's the difference between legal and political? There's another very interesting discussion about legal is backward looking, precedent, backward looking, building an argument, and political is forward looking, right? Policy and moving forward. But in the article, there's a lot of little sentences, well, not completely backward looking, not completely forward looking. But when it's said and done, legal institutions are more backward looking and political institutions more forward looking. All right. So I said, wait a minute. Okay, what's going on here? And then if you look further, and this is not just in the paper, but in some of his works, it seems to me that what he's saying is that why is it no big deal? It's no big deal in part because what constitutional law is a sum of all the actions of political and legal institutions. Not only that, it's a three-dimensional model in his works. And the three-dimensional model is, in fact, you can't stop the process at any one point, right? It's three-dimensional. Therefore, if you say the court said this, who cares, because we got the court doing, we got politics doing this later, and, Brown v. Board, no big deal, but not as big a deal. And you bring in Rosenberg's work and other people's work. Okay. So it's a matter of an infant regression of no big deal, because in fact there is no answer to the question about whether this law is good because you can't stop it in time. Now what's going on here? It's a very, very subtle notion of dialogue, that there's a constant dialogue between courts and political institutions. I said, great, dialogue, dialogic, sounds interesting. Okay. When you look at the word legal and political, you find out the dialogue is really in one direction. I can't go into this, we want to talk about other stuff, but the dialogue is in the direction of the external to the internal. All right? Because there's no specification of what the legal is within courts, right? And because the legal in courts has something to do with interpretation, something to do with backward lurking, and in politics, legal is using legal arguments, because in fact there's no statement about the legal and the political in courts versus political institutions, right? Because there's no sort of theory of that difference. And what you get is you can't really explain. Why is that? The chief point in the article is a very, very interesting point. Law is simultaneously political and legal. Okay, I said, yeah, that's true. It's simultaneously political and legal. The question is can you parse out separation between the two in courts versus political institutions? In other words, both are both, but courts are legal in a very, very different way than political institutions. They're legal in courts because there's an analogy process. They're legal in courts because they use principle. There's legal because, I would argue, in a paper that's in these materials, what I would call the social construction process, where you take the principles and you take the thing, and then you build them out and bring the outside in. And therefore, I would argue that the process is not simply from the outside in, but it's bidirectional. The court is taking principle. The court is taking other cases and other analogies, bringing in the new one, and it's saying, is the duck in the past like the duck today? Why am I so concerned about this? How do you explain Lawrence v. Texas in a conservative era with a conservative court produced by Republicans producing Lawrence v. Texas in terms of gay rights? In other words, how do you explain Casey? In other words, I would argue you can't explain these cases by just saying it's external on courts. Now, this problem is a problem that is present throughout a lot. Political science historians. In other words, they take the given of the court as epiphenomenal, not explanatory, to to what courts do, and they assume it, and we saw it today in almost all the papers, it's the outside in. And the judges are shivering. The judges are afraid. Whether it be in the wonderful stuff on their salaries or another one in terms of thing. But the problem is that there's no discussion of what the judges do on the other side. Now notice what the thing is. The outside world are political institutions and the courts. But the outside world is also in what courts do, and maybe I'm just talking about privacy, but it's to live lives of people. And if you look in the Casey decision, the court is trying to look at these principles and Roe v. Wade and when you look at Lawrence and Bowers and stuff like that, what they're trying to do is ask the question is, when you look at lives lives of people relative to principle of privacy that have been developed, is it a duck or not a duck? In other words, the only way you can explain cases like I've mentioned that are so outside the realm of the majority coalition outside the realm of the external explanation is to suggest there's something going on in the court that has an independent effect or a different effect on what the court does. Now, I'm not saying this is true in all areas of constitutional law, but I am suggesting that this bidirectionality with regard to the court is very, very important. In other words, and this bidirectionality, it becomes relevant to the Constitution Restoration Act, because that's no big deal, but Marci, thank you, Marci, you wrote, I'm not writing it, I'm just looking at your paper, but what Marci did is list the other nickels and dimes that are on the table in quarters, half dollars, stuff like that are on the table. Now, why are we saying this? I agree with Marci 100%. What Congress is doing is getting into the heads of the justices, so in fact, they don't have the discretion, what I would argue, to engage in the social construction process. Now, why is this relevant? It's relevant to the non-U.S. materials. In other words, part of what a judge does is decide what types of the world outside help me decide is it a duck or not a duck. And if you can't use non-U.S. laws, or you can't use, sort of this process of I would argue non-originalist social construction process, and you start limiting it, then judges, in fact, are going to, and this Marci said it better than I am, judges, in fact, are not going to be able to do what they're doing. Notice what I'm saying: liberal and conservative, but not originalist judges. Right? Look at, O'Connor, Kennedy, and stuff like that. Now, why is that so? I'm not going to go why that's so. It has something to do with the nature of complexity and how analogy works and things like that. So the problem is the lack of separation of the legal. It's not that, I think he's right, the legal and the political are together, but the court in their processes, you can see different aspects of it. And you can actually follow in cases, if you look at lines of cases and patterns, and find this sort of the outside coming into what's going. Now, why is this important? Because if you think that the outside is coming into the world and the court is looking at the outside and it's bidirectional, right, then in fact, when there's an effort from the outside to limit that bidirectionality, right, to limit the principle and the theory in past cases to what's outside, then you're on the way to trying to close down the courts. Now, look at the Alito hearings. Look at the hearings, with Roberts. It was all about, do you believe in precedent, right? Everything was, do you believe in precedent? Why is that? All of the questions of you believe in precedent are, do you believe in the social construction process? Do you believe in principles and construction and doing this analogy and duck comparison? That's what all the debate is about. So every question is, how far are you to go to argue that the past and the principles there, how far do you support the Casey decision, not in its outcome, but in that formulation about what courts do, which is the more important part of that case in a certain sense. Because the Casey decision is where you see this sort of bidirectional theory of Supreme Court decision making at work. Now, there's something else going on here, and I won't talk about it now because time is a limiting or something like that. But there's another aspect of this and the possibility of social science. Mark's work has been terrific in looking at Thurgood Marshall's work, in looking at race, and looking at all this stuff. But if you look at the page, there's a question about whether you study history on the retail or wholesale. Let me show you the difference. You can say that, in fact, you can take a lot of different cases with a lot of different things and see a lot of retails, going on, but argue that there's reasons why there's no wholesale going on over periods of time. I would argue that the primarily external nature of Marx's analysis, right, outside in, and outcomes, that analysis sort of, I think, misstates what courts do, but it becomes very much like something in old 1950s, 60s term, Lowy's terms, interest group liberalism. In other words, what you have in the world, and it's a very sensuous thing for Marx, what you have in the world is a bunch of institutions, courts, mobilization groups, political institutions, Congress, all of them there, right? And what you have is a unstated position in the popular constitution, the unstated position that what's going on is basically everybody's doing law and political stuff, right? And there's an implicit notion of, in the popular constitution, if everybody does it and we stop judicial review in a sense, in terms of this, that in fact the outcome will be better, than in fact taking institutional difference seriously, right? And I would end. Now, notice what's going on here, too. If you take institutional difference seriously and ask how this bidirectional process goes in courts and how courts work with their boundaries versus political institutions with their boundaries, if you do this, you're going to find, in fact, that they're not the same. The legal and the political in both are not the same. What that means is there may be a cumulative effect to the law. There may be an aspirational effect from this process that isn't necessarily true in Congress. Now, what I'm arguing is institutions make a difference and you can pattern them. I'm not arguing that the court is always liberal, and I'm not arguing Congress and politics is always conservative. What I am arguing is that this bidirectionality between politics and the outside and court and the inside, this bidirectionality, if you can study it over time historically, will in fact get you at a better sense of the nature of independence. One last point. A new book coming out, the Supreme Court and American Political Development, where Mark is in and Gilman and Novkov, a whole bunch of people, Tushnet and stuff like that. I need the $50. I need the 50 cents a book. I'm not saying that. But let me suggest that this bidirectionality is in almost all of these things. And they take the law seriously, what goes inside, and they take the outside seriously. And over time, you can see this relationship. We hope it'll be contribution both to constitutional law and legalists, but also to students of American political development. Thank you.
Two things to say. One is a question for Marci, which is basically, what do you think about my no use of Latin statute? Because I could understand a categorical rule against prescription of interpretive methods. And it would in some sense work. But again, my intuition is that there are some interpretive things that Congress can do, and then you're off and running when it's a continuum. Okay, that's
well. Let me just respond by saying the reason that I didn't respond to you in my presentation is because I think you're right. I think that everything it's just right. I mean, this is probably would pass muster. On the other hand, that doesn't make it good. So really, my response is more of a judgment rather than application of the doctrine. I think you're right about that.
Oh, that's fine, and it's certainly easy enough to defend the position that the RLUIPA or RFRA as interpretive directives are so much more extensive than the elimination. Okay, fine.
Yeah.
Now, on Ron's point. I guess I want to say I don't disagree with the bidirectionality point. It's when I did a little version of this for a bunch of federal judges 2 weeks ago, their reaction was, well, yeah, of course it's unconstitutional. Not surprising, that's their reaction. But then the question is. Yeah, you may think so, but you're never going to have a chance to say so, because in the context of the only way this is going to come up is in the context of an impeachment over which, according to the Walter Nixon case, you don't have any authority. And you don't have any authority precisely because we know this is the kind of thing that you're going to think is unconstitutional. I mean, that's what Walter Nixon says. You're in the context of judicial impeachments. You're not going to be interested in protecting the Constitution. You'll be interested in protecting your friends. So this is a situation in which, although I agree in some sense, and I say this, I want to be more clear in the paper, there is a law of impeachment. I want to be clear about that. But it's a law that's developed in some sense unilaterally.
Questions?
Just a little kind of lowbrow question. Is there some tit for tat going on here? The court has been, in the words of one author, dissing Congress, has been somewhat disrespectful of congressional processes, particularly with respect to fact-finding in the 11th Amendment / Section 5 cases. Is this, at least in part, this being the the Constitutional Restoration Act, in part a response to the court's disrespect, at least in congressional eyes, for congressional processes? I know that, for example, Senator Specter sent letters to now Chief Justice Roberts about his views on respect for congressional fact-finding. And now maybe we're seeing the same thing going backwards towards the court.
Well, Senator Specter actually, his office called me about a month before the break and to say they were going to have hearings on why it is the court thought it had any authority whatsoever to limit him. And I said, well, it's really not personal. It's just structural. But I think there are going to be hearings. Now, what I think is so interesting about Senator Specter, though, is that this has been going on for a few years. Right? For him, it seems to have just registered, but it's just registered after the Supreme Court just actually applied the federalism doctrine with hardly any bite. So it seems to me odd timing. But yeah, I think there's some tit for tat. But having said that, the truth of the matter is, whenever any legislature calls a constitutional scholar to testify, it's because they think it will be useful in hiding what their actual interest is. It's true. It's true. I've never testified when I didn't eventually find out who I was covering for. So, I'm not sure they really care that much. They have 1 billion laws, right? 5 have been held unconstitutional. I don't think they feel too threatened.
Well, and I also think that this is, this controversy of which this is the reference to non-U.S. law is sort of it's a culture wars issue through a distorted window. They're not really concerned deeply about the members of Congress. I don't want to, whatever Justice Scalia or Justice Thomas think, I don't know, but members of Congress aren't really concerned about the references or reliance on non-U.S. law. They're worried, they're disturbed by the cases in which that has happened. That's why I suggested the Justice Kennedy strategy at the end, or just another indication of it. In the, I think it was McCreary County case, the posting of the Ten Commandments case, in which a majority held the posting to be unconstitutional. Justice Scalia's dissent says, look at what's happened in France. We don't want that to happen here. Nobody mentions that as an impermissible reference to non-U.S. law. And I suppose there's no secret, and it's not hard to figure out why.
Mark, I was sort of fascinated by your comment just now that the issue, the constitutional issue, could come up only in an impeachment hearing. For example, let's imagine a situation where the statute said that judges could only decide based on the text, the actual words of the Constitution. Or let's imagine the actual language that we have dealing with, that we're dealing with now. Isn't it possible that a litigant would have a ripe controversy, or at least have an argument for a declaratory judgment on the grounds that a whole area of law is off limits to the judges deciding his case?
Maybe so, although there'd be a sort of, I think there'd be a serious ripeness kind of problem, because no litigant would know that a judge would be relying on non-U.S. law in the case that the litigant wants to bring. But I have to think about that.
Yeah, no, but I mean, that's why I used the slightly more extreme example of limiting them to text, for example. You know, I guess it would be more predictable that if you're arguing, let's say, a Fourth Amendment case and you're stuck with text, that it's not going to be so good for the defendant, so it's a riper issue. But I was a little taken aback by the idea that it could never come up other than an impeachment.
Yeah, and that may well be right, that the issue of, well, we know that the issue of limiting interpretive techniques can come up in ordinary litigation, because it came up in Lyndon Murphy, and as I understand it, I couldn't find it fast enough. The same issue, the Lyndon Murphy issue, is now pending before the Ninth Circuit en banc, and so there are contexts in which the constitutionality of limiting interpretive techniques can be adjudicated. I guess my thought was this was not one of those contexts, but I'd have to think more about that.
Okay, thank you.
Well, maybe just because the remedy, I mean, the way the statute operates, it's only triggered if you're trying to get someone removed, right? I mean, because it says, it's just the CRA's craziness.
Well, I mean, it says you can't rely on it, which means...
maybe you could do it individually.
Yeah, right.
But it doesn't give you a remedy otherwise.
Right, that's right.
This is actually a broader question for this panel, I suppose, but it occurred to me in listening to this, the political reality that the best friend of most politicians is judicial independence, because they get two bites at the apple. They get to pass the law, and then they get to scream at the Supreme Court when the Supreme Court strikes it down.
Precisely.
I mean, this is the deal about why the Republicans are scared about having Roe versus overturned, because for so long they've used it as a galvanizing mechanism to keep folks in play. And my question to all of you, maybe to Mark Miller as well, is to what extent does that dynamic factor into the issues that you're discussing?
You have to be a Machiavellian for that. Let me just suggest. Right. No. This argument gets to the bigger question of what we get out of the courts is what the majority coalition really wants from the courts anyway. Therefore, you can explain every decision based on that premise, i.e., we get Casey because it takes it out of politics. At the same time, we go after it. And so, at the same time, Casey has principles within it that have an effect on Bowers and had an effect with regard to Romer in overturning Bowers. All right. Now, so in other words, if you look at the process way they can do it, in other words, you're very smart. You can always fashion an argument the majority is always getting what's what, because you have all this list of horribles that if it went the other way. All right? But it's not clear to me that that because Karl Rove uses Lawrence case or uses the Massachusetts case, that therefore the political majority wanted it. It may have been that they used it politically, but they may win from it because they're very good political operators, but I think it's a far stretch to argue, the political majority got what it wants, and therefore, the court is just sort of being affected by external politics.
One thing, your question does go much broader than anything that we've talked about so far, but one of the things that might be happening, of which the introduction of the statute proposal may be a symptom, is, and this is just a claim on my part, which would have to be defended, that the nation is significantly closer to what I would call regime transition. than it has been for decades. Now, that transition may not occur, but one of the things that happens in this sort of setting is odd proposals get made. And sometimes, if the transition actually occurs, they may end up getting stuff they didn't really want. That is, the institutions after the transition may be not exactly what they wanted beforehand. And that, I think, is the overturning of Roe and Wade kind of idea. So anyway, that's my reaction. And you know, the claim about regime transition needs a much more extensive
what's the
kind of
transition
defense.
now? What's the nature of the transition now?
Well, it's all the stuff liberals don't like. It's going to the transition would be to a whole bunch of stuff liberals don't like, systematically rather than randomly.
Well, I want to build on Mark's suggestion that we take this proposal seriously and sort of move the focus a little bit. At one level, this may be a piece of the culture wars, but if we take it more, if we take it seriously, it also goes to what constitutes a legitimate source of law and interpretation. And we've seen that kind of debate in various settings in a lot of different places. We saw it in connection with Brown when the argument was that this wasn't law, it was sociology and politics. A lot of the debate about law and economics and is the common law efficient relates to the Posnerian notion of the decline of law as an autonomous institution. This is a different sort of setting, but I mean, can we think about this as another piece of an ongoing conversation about what the law is or where we should look for it, and in that sense, even if we might think that this particular proposal is really strange, situated in that larger setting, or am I missing something?
No, I think that's exactly right. The qualification I would have, and this I was struck in both the Roberts and Alito hearings, is that the question about proper interpretive methods is something that academics worry about, and that under some circumstances politicians make noises about. But people who are good, that is, good at the craft of judging, know that you use whatever you think is useful. And in the Alito and Roberts hearings, they had to be forced to say they were going to be originalists. You know, everything, most of the time they said, I'll, you know, look at stuff. You know, they won't look at foreign law because, you know, their sponsors don't want them to look at foreign law. But I think this is a small issue. But what I found most interesting was the reluctance to commit to any interpretive approach, because I think they understand that the craft of judging is to use what seems useful.
Well, I mean, with respect to the confirmation hearings, it actually goes to the point I was making about the infinite increase in power of Congress, because if you watch these hearings closely enough, if you could stand it, the message was precisely the opposite of independence. The message was, you are accountable to us. And the subtext was, there's a presidential election coming up, and you are doubly accountable to us. So you better tell us what you're going to deliver for us. Now, we don't want you to tell us what you're going to say in a particular case, because then you'll be recused, and we want you to go our way in that case. But to the extent you can, you're accountable to us. And so that transforms the relationship rather dramatically. Right? I mean, I understand that we have a long history of political challenges to candidates, but this particular set of exchanges was really about a message of don't cross the line. And that alters what it does because everyone wants to be consistent with respect to their own statements, is Alito and Roberts walk into the court carrying this baggage of what they've had to say in public, and it's going to limit what they'll be able to say on the bench. Yeah.
But I think the issue basically was, I am not Alito and Roberts. I am not an originalist. I believe in looking at the world outside. Then the question is, okay, you're looking at the world outside. What comes into your sphere in looking at the world outside? And therefore, as long as you could show you weren't it didn't work, but as long as you can show you weren't a Bork, or a Thomas, then maybe there's some hope. And maybe there's some hope, that Roe won't be ordered, stuff like that. So I think the line between being an originalist and being a conservative, non-originalist, that line's an important line, and what the Republicans are trying to do is getting as many people close to the line of being originalist but not being an originalist, so that you don't know what goes into the decision-making type of thing. But it didn't work. The Democrats are saying we don't like what's in the mix.
Just on Marci's point about, pushing nominees, I thought the one characterization of then Judge Roberts' testimony is that it was like the oracle at Delphi. There's no future behavior he could engage in that would be inconsistent with anything he said.
He's good.
Because he was really good at
He's
that. So now, and Alito tried, but wasn't quite as smooth at it.
But look at the Alice in Wonderland situation at the Alito hearings. You end up having 7 judges testify. Now, that's just bizarro. I mean, I clerk for Judge Becker, and I love him dearly, but that was bizarre. And all of them said the same thing, right? If you watched it as I did. Said exactly the same thing. He's a great guy. He's a wonderful guy. He's going to be unbiased, as subtext, just like I am. I mean, it's just a very odd. The fact that they felt they had to go and do that is a radical alteration in roles. And it's, I didn't think he should have done that.
I guess I'm thinking about the Schiavo case and the legislation that was passed by Congress. And I'm thinking that the same folks who were supporting the Constitutional Restoration Act were the same folks trying to force the courts to make a decision. And then I think about the Alito and Roberts hearings. And it brings me back to this notion that, especially after the Schiavo case, some members of Congress really want judges to be using political decision-making, as Ron's point sort of was. And the judges want to be using legal decision-making, which I agree are 2 very different things. What I'm struck by is after the legislation passed Congress on the Schiavo incident, public opinion polls were overwhelmingly negative about Congress. Now, I'm not sure the average person on the street can articulate, we want judges acting like judges and we want politicians acting like politicians. But I think that's what, in part, was going on there, is that they saw Congress as overstepping its bounds. And in other ways, some of the reasons things like this Constitution Restoration Act won't pass is because even though the public may not understand the details the way academics do, they still have a sense that judges should be judges and politicians should be politicians.
You see that also with President Bush and the use and not getting a writ from a court. The same exact thing. Well, there's something wrong here, but we can't articulate it. And I think there's a similar type thing going on in this.
Well, I mean, it's my view the Schiavo affair, as I call it, was the top of the pendulum swing. American politics always runs on pendulum swings, especially when it comes to religion. And what happened is that the conservative evangelicals have been very good at operating behind the scenes. We could see the effects of it, but the effects were kind of odd because they were things like increasing federal spending. And it's not really a normal, it's something wrong with that. Once they showed their face that this was what they were capable of doing, they could bring Congress and the president into Washington on a weekend and get a bill passed. I think the American people said, wait a minute, I know you're powerful, but I know you were that powerful, and I think we're seeing a shift. I mean, and then we get books like Jim Wallace's saying, they're not the only believers in the country, I'm a liberal and I'm a believer. They can't have the... So I do think that that was a defining moment, but from my perspective, it was more of a defining moment with respect to the relationship between church and state than it was with respect to between Congress and the courts.
Can I just say one thing about the Schiavo case? I wish I had an opportunity to write something about this, but I don't want to, it's not worth it. The statute was incredibly badly written
Yes.
from the point of view of the sponsors, and the case was badly litigated by the Schiavo parents' lawyer. And at the end, after it was over, the real supporters of the Schiavo parents were essentially saying to the courts, we're mad at you because you didn't do what we didn't tell you to do. Right? It was judicial activism not to do something.
Yeah.
But they hadn't been told to do it because it was a badly written statute from the sponsor's point of view.
Well, the statute actually started out directing the state courts. It was very powerful. And in the conference meeting, it got gutted and ended up being nothing. So.
Time for one last question.
The peasants are revolting.
That's right. I'm not ready.
Please join us all. First, I think we should all
was fun.
join together and thank the organizers of the conference for putting together this day. And there's a reception following right now back under the rotunda. So please join us there for drinks and goodies. And thank you all for coming.
I think I stayed within my time.